adjournments remaining two. So we are hearing it.
May please, Your Lordship. Lordship, prayer for listing a I Lordship for bail, Lordship, and a 76 years old person in jail, Lordship, more than 2 years.
6-year-old person in jail.
Lordship, more than 2 years, Lordship.
76.
76.
76 is 6-year-old.
76.
So
Can it be to day after tomorrow, Lordship? And earlier I have made mention on 12, Lordship, but
you
not
want for what? You want for bail?
bail, Lordship. Day after tomorrow, Lordship.
Okay. Let's
Deeply obliged.
Wait, please, Your Lordship. I beg to mention item number 6. We have taken consent from the other side. We have also given the.
Yes, okay, right. Adjournment prayer has been made on behalf of the appellants, which is not objected to by the learned APP. Accordingly, list this matter after. Give a date. List this matter on. Give a date.
Deeply obliged.
Lordship, I beg to mention item 8 for the adjournment. I guess adjournment slip has been given.
Okay, right. Adjournment prayer has been made on behalf of the appellant.
Lordship, can be listed up
Appellant's counsel.
Be-
Appellant's counsel.
vacation.
It is not objected to by learned APP. List the matter on.
after Bihu vacation as my standing counsel is.
Yes,
that's
yes,
fair.
we will list it after.
Okay,
January? 24. Anyway, doesn't matter. February. Anyway, yes.
No, please, Lordship, I beg to mention item number 5 of the daily list.
Five.
Yes, ma'am. We have
Yes.
submitted the adjournment slip and have
Okay, on the prayer for a, no, this is amicus.
to make us clear. Mr.
Why?
N.J. Das.
Why?
Lordship is here.
Since 2023, he's been absent or asking for adjournment. We cannot allow.
Lordship, I will inform him.
We're giving you one last chance. We'll write it in the order. If he does not appear anymore, we're changing him. We're putting another person, right?
Lordship, I will-
Adjournment has been made on behalf of Mr. N.J. Das, learned amicus curiae. We have noticed the orders passed by this court since the year 2023, wherein the matter has been adjourned on the prayer made by Mr. N.J. Das. Full stop. The matter is being adjourned for the last time. Full stop. In the event, adjournment prayer is made by the learned amicus on the next date. This court would not probably change the amicus quick. This matter be informed to Mr. N.J. Das by Mr.
I Hussain.
I. Hussain, who has asked for adjournment on his behalf.
Lordship.
List the matter on, give a date. Cannot have it adjourned all the time.
Fine. Deeply obliged.
May please, Your Lordship.
Appellant who submits that the appellant has been convicted under section 126 bracket 2, section 137 bracket 2 and 65 BNF. Read with section 42 of the POCSO Act. While judgment dated 25/9/2025 passed by the special judge bracket POCSO, Kachar Silchar in special POCSO case number 257 of 2024. Arising out of Udar Bond PS case number 115/2024. Admit the appeal, call for the TCR issue notice returnable in 4 weeks. Mr. R.R. Kaushik, APP accept notice on behalf of the state. Appellant to serve a soft copy of the appeal petition to the office of the PP, who shall forward the same to the OC of the concerned police station. Full stop. The OC shall thereafter serve a copy of the appeal petition to the respondent number 2 and make a report thereafter. This is the matter of 4 weeks.
Like,
May it please the lordship. My lord, I, I ordered it at 2/5/2025, my lord. Today we consideration.
They are eyewitnesses.
Lordship,
May-
in item number 11, if I may make my submission. With regard to the IA, the only ground which was taken in the IA was with regard to the medical condition of the applicant. He's a cancer patient. So at this stage, he's in a stable form. So I don't press the IA at this stage. But if need be, I will mention the matter.
You
And,
withdraw this IA then.
Lordship,
You withdraw, you file again. We cannot keep it pending just like that.
Lordship may dispose it of as not pressed, Lordship.
Okay, yes. Okay, in this IA,
Item number 11.
item 11, huh? IA 486 of 2025. Dr. P. Agarwal, the learned counsel for the applicant, submit that the application has been made for suspension of the sentence and bail on the ground that the applicant was suffering from.
He is still suffering from cancer.
However, his condition as on date is stable and she does not wish to press the application. Full stop. Ms. B. Bhuyan, APP appears for the state. Full stop. She submits that in view of the submission made by, no, appears for the state. That's all. On considering the submissions made by Dr. P. Agarwal, the application is closed as not pressed.
With liberty.
With liberty to file a fresh application. With liberty being given to file a fresh application.
Lordship.
Full stop. I is accordingly disposed of. Then in the your IA, item 10 IA. Yes. 4, 5, and 6.
yes, my lord. Four is the brother-in-law of the deceased, my lord.
Brother-in-law of the deceased.
My lord.
So, what is wrong? Do you mean to say that interested witnesses testimony
My lord.
cannot be relied upon? Is that your case?
Yes, sir.
Okay. Show us. Why?
Allegation against the present appellate Rafiquddin is that he struck Nizamuddin with Tarwal, your lordship.
Talwar.
Tarwal.
Talwar.
Talwar ko in English,
Talwar.
Hindi, I don't.
In Hindi, it's talwar. Talwar is sword.
Sword, my lord.
As per evidence of PW to me.
So your case is PW4 is the brother-in-law,
My lord.
and thus he cannot be relied upon.
My lord. Can I please the judgment, my lord?
Sure. Please place 2 copies.
Yes.
At 22, my lord.
Yes.
It is the first and foremost important to note that it is a well-settled principle that when the witnesses are related interested, their testimonies have to be scrutinized with greater care and circumstance. That's another judgment is said, my lord, this judgment also I have this. And para
Huh?
23, my lord.
Yes.
In the instant case, the two Kai witnesses are son and wife of the deceased, who are very well interested witness in this. Therefore, their testimonies have to be treated with great caution, required to be met with a stricter standard of proof and deserve to be scrutinized in order to rule out any establishment.
Correct. With,
31, 33 and 31. madam.
Huh?
Thereafter 33, 31, 33 and 34.
Yes.
Thereafter 31, my lord.
Yes.
This improbability gains even more prominence in light of the fact that,
What improbability?
my lord,
What improbability?
I'm reading my,
I know, that's what it says, this improbability.
my lord.
This improbability is in relation to this case. Now, what is the improbability in relation to this case?
I'm reading another judgment, my lord. It is recent judgment, 22 judgment.
Yes, that's the.
Yes,
Para 51, my lord.
para
51.
one. Of which
Second judgment.
okay. Yeah,
It is thus settled that the evidence of the related witness have to be considered by applying discerning scrutiny. In this instant case, it is seen from the testimonies of the prosecution witness that all the witnesses are related to the deceased accompanying and therefore all the witnesses being related to the each other. In order to elucidate on the said aspect, it is pertinent to note the relationship of the witness and the deceased Akbar Ali. PW1 in his deposition stated that the deceased Akbar Ali was his cousin's paternal uncle's son, and PW6 is the husband of the niece. PW2 stated that the deceased Akbar Ali was his paternal uncle. PW3 and PW4 deposed that they were brothers of the deceased. PW5 was the brother-in-law of the deceased, and PW6 stated that the deceased was his maternal uncle-in-law. It is necessary to state here that the evidence of the related witness can be rejected if there are material contradiction and inconsistencies found in their testimonies. It is observed that there have been material improvements in the testimony of PW1 in his examination deposed that the accused Jabbar Ali stepped Akbar Ali. However, in his cross-examination, PW1 stated that he had not told the police that MD Jabbar Ali stepped Akbar Ali. The same is in improvement in the testimony which has to be borne in mind. Well, in this case, my lord, 4, 5, 6, 7, all are interested witness. All are brother-in-law. 4 is the brother-in-law of the deceased, my lord, and 5, 6, 7 are the brother of the PW4, my lord. And PW1 and 2,
all of them are brother-in-law of deceased then. If PW4
my lord,
is the brother-in-law of the deceased,
my lord,
and if 5, 6, 7
my lord.
are the brother of PW4, that means 4, 5, 6, and 7 are all the brother-in-law of the deceased in a way.
My lord,
In a way.
my lord.
So not exactly. Okay. So anyway, so how does it matter? You have got to show that there are material contradictions between them.
And
Unless you can show that there are material contradictions in the evidence of PW4, 5, 6, and 7, then only you can take help of this judgment. Otherwise, it doesn't help you.
it's right, my lord. Paper is not that, my lord. That is why.
Paper book is not
Required,
required.
my lord.
Paper book is there. The judgment is there. Show us from there. And then when you file this application,
Right.
what was the basis for filing this application then? What was the basis? If you are relying upon the judgment, when you started drafting your application, did you consider this aspect that this judgment would be taken into consideration?
Prosecution, my lord, has not examined any individual witness, my lord.
Individual witness?
Yes, my lord.
Individual witness. What individual witness? Huh?
Independent witness has not
So
examined.
independent witness are examined.
My lord.
No, okay. Independent witness, so these are not independent. According to you, they are related witnesses.
My lord.
Okay. But then that does not take away the fact that even their testimonies can be considered. Only thing is that to show that their testimonies cannot be taken into account, we have to show that there are material contradictions in their evidence. You have not been able to show that. When you filed your application, what is the basis for filing? Or was it that you'll file an application and then you'll find out the reasons for filing the application? Huh? That's what. Yes, madam.
Lordship. Evidence of Lordship PW2, PW3. And PW4 also, your Lordship. PW2 and 3, my lord. But specifically named the accused, my lord. The instant appellant, my lord.
2, 3, and 4 are eyewitness. 2, 3.
Yes.
3
Yes,
eyewitnesses.
3 is the eyewitness.
3 is the eyewitness.
Yes.
And 2 is the eyewitness
Yes,
of.
my lord. Then 4, my lord,
4,
PW4.
no.
Rafiquddin cut the deceased dagger.
Leave aside 4. Yes, Mr. Counsel, is 3 a independent witness?
No, my lord.
Not independent.
Not
What
independent.
is he? Related to the deceased.
He,
Both sides are known to him.
both sides are known to him.
So how does it matter? Related and known are different.
Merely because they are related, their evidence cannot be thrown out. in
Just
total.
because they know the person doesn't mean that he's an interested witness. And he knows both sides. It's not that he knows only one side.
PW3, my lord, in his clause, he said, my lord, page 30, my lord, he stated that he had not seen Yakut Jalaluddin, son of Late Abdul Nur, at the place of occurrence. He denied the suggestion made by them. He stated that he had not seen how Nizamuddin sustained injury, my lord.
That is one witness. So who is that?
He also could not,
Whose evidence is that? PW?
PW3, my lord.
PW3. He did not see.
He
So
did
he's
not.
not an eyewitness.
No, my lord.
PW3 is not an eyewitness. That's what you speak.
15. Senate is another thing.
2, what about 2?
Lordship, he says PW3, he was cross-examined. He stated that he had not seen AQ Jalaluddin. He is representing Rafiquddin.
Rafi, no, later part.
Yes. He denied the suggestion made
He
at
also
defense.
could-
He also could not state as to who was possessing the land at the time of incident.
Yes, we're trying to understand you, but I don't think you filed the article.
Or he had not stated.
Tell me to pass the article. Right. Okay, I heard Mr. A.K. Azad, learned counsel for the applicant. Also heard Ms. Bhuya, learned APP for the state. This application has been made under section 389 or 430, which one? IA is
IA.
for
430.
430 BNS.
এখন নাকি তোমার 486 হবে?
389.
389, my lord.
389
486 is by 430.
CRPSC. For
এটাই আছে না আমার ওখানে না।
suspension of the sentence
344. Absolutely very sad.
awarded to the appellant in relation to the judgment dated 28/11/2023 passed by the court of the additional sessions judge, FTC, Karimganj, in sessions case number 77 of 2010, by which the applicant has been convicted under section 302 IPC. The applicant's counsel submits that the finding of the learned trial court that the that the applicant was guilty of having committed the offense under section 302 IPC has been made on the basis of interested witnesses. Interested prosecution witnesses number 4, 5, 6, and 7. Correct. He submits that PW4 is the brother-in-law of the deceased, while PW 5, 6, and 7 are the brothers of PW4. Next one. The learned counsel for the applicant submit that in terms that the Supreme Court in the case of Ishak Kimuthu versus State represented by the Inspector of Police 2025 0 INSC 880 had held that when witnesses are related / interested, their testimonies have to be scrutinized with greater care and circumspection. Inasmuch as, they are required to be met with a stricter standard of proof and deserve to be scrutinized in order to rule out any embellishment. He also submits that the Supreme Court has, in the case of MD Jabbar Ali and others versus State of Assam, reported in 2022 0 AIR bracket SC 5420, has held that the evidence of related witnesses can be rejected if there are material contradictions and inconsistencies found in their testimony. Full stop. He accordingly submit that the learned trial court did not consider the case of the testimonies of PW 4 to 7. With discerning scrutiny and as such, the evidence of PW 4, 5, 6, and 7 cannot be made the basis for convicting the appellant. Next para. On the other hand, Ms. B. Buya, the learned APP, submits that there is nothing to show that the evidence of PW 4, 5, and 6, 4 to 7 contradicted each other. He also submits that PW2 is also an eyewitness who saw the appellant committing the crime of killing the deceased. Next part. We have heard the learn of the in the case of MD Jabbar Ali, the Supreme Court had held that the evidence of related witnesses can be rejected if there are material contradictions and inconsistencies found in their testimony. However, the applicant has not been able to show us the material contradictions and inconsistency between the evidence of PW 4 to 7. Further, the Supreme Court in the case of Dash versus Dash has held that the evidence of related witnesses can be consistent. Next. On considering the facts of the case, somehow we prima facie are of the view that no case for suspension of the sentence has been made up. Accordingly, the application is rejected. And in the main case, we write as TCR has arrived, registry to prepare the paper book. List the matter on given date. Right? Yeah. Some slightly more industry. Yeah. Oh, no, I don't know. It could be done by a board. To be good. Yes,
Yes, your lordship. At first, I take your lordship to page number 6. From
right?
lordship, page 75. Lordship, kindly.
Why are you not reading the other portion?
Lordship, it is better.
Why?
Otherwise, by and then your lordship kindly come to next page, page 76. On 2/11/2021, he committed rape upon the victim. Thereafter, she went with the accused appellant at Nibias, and then her mother lost the Azahar. Next page, the entire incident to her. She asked me to forget about the same and not to inform anyone about it. In the evening,
Page?
next page, lordship 76. In the evening, my cousin Liton Roy took me to his home. On the next day, Jana Roy and my grandmother Malati Malakar brought me back home. On 4/11/2021, 5 p.m., I along with Nepal Roy, that is appellant, he committed rape on 2/11. And thereafter on 4/11, he went to the Lordship present appellant. Is it a believable story? And in her cross, before the trial court, that she accompanied with the accused appellant at Guwahati prior to lodging of the Azahar. There is no whisper that at that point of time he committed any bad act with the alleged victim. So there is a lordship, they are the relative.
Let
Yes.
us see the FIR. FIR is what did?
Lordship, it is
Kidnapping, madam.
missing.
Page 4, madam.
I have to honor, may I read, Lordship? I have the honor to speak,
Just a minute.
Lordship.
Don't get excited. 7/11/21. Informant is mother.
Mother,
PW.
PW2.
You are for the mother.
I'm Mike Asmalo for the respond number 2, yes, madam.
You can only assist.
Yes, madam. I can only assist.
So, Lordship, Azahar lost on 4/11/2024 in her 164 after recovery.
Ejahar lodged on 7/11.
Yes, sorry, Lordship, 7/11, but incidents stated to have occurred on 4/11/2021
But according to us, 164, it occurred in 2/11.
to 2/11. And thereafter he went with the accused.
She,
Is it a believable
not
story?
he,
Lordship?
she.
She, Lordship.
Hmm.
She went to the accused after committing 2 days of the committing rape. Is it a believable story, Lordship?
I don't
And
know.
he's aged about 38 years, all along helping this family, Lordship. At that relevant time, they asked, that is in the cross, whether it is a believable. There is no whisper that he threatened the alleged victim not to disclose any such immoral act that he committed. That was no whisper, either in the trial court or before the police. And my humble submission, charge is not proved. Learned trial court, perhaps it is forgotten that charge was framed. It is at the house. Otherwise, charge is not proved. He was put to the notice that Ellie's incident occurred at the house. So he defended. He nowhere in his cross stated that such contact. Why he to say? It is his right to remain silent. Prosecution is to prove their case. It is their case that on 2/11/2021 he committed rape. They failed to prove that aspect. New story for the first time in the trial that no. It is only after returning from Libya, that is after 4/11/2021.
Where is that?
Lordship, it is at the evidence.
Huh?
At the evidence.
What's that?
Lordship.
You got
Lordship, evidence of PW1. The informant is my mother. The occurrence took place last year after 2-3
PW1 is the victim.
victim.
Hmm.
Yearly Kali Puja at about 8 p.m. During Kali Puja, I went to the house of my aunt Miton at Nibia. Miton is the Lordship sister of the present appellant.
You are related.
Related, Lordship.
You are related to the victim also.
Yes. His uncle, Lordship, all along he accompanied the present appellant. It is
Blood
from the-
relationship or uncle only? There is a blood relationship.
not blood, but it is a filial relationship, Lordship.
Filial relationship.
Yes.
The father of the victim, and this person is the husband of the sister of the father of the victim.
What?
No, 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 no.
Just what? The father, the
The
victim
victim's
father.
father is
Parent?
appellant is the husband of the sister of the victim's father. Peha.
Okay. Huh? Please,
Lordship,
brother-in-law.
He is brother-in-law, own brother-in-law,
Law.
own brother-in-law.
So you are the brother-in-law.
no, no, no. Lordship, Lordship, kindly have a look. I went to the
No. Is your wife
no.
the
he-
sister of the
No, Lordship, her paternal aunt is my aunt is
you are your own grandfather?
not Lordship, it is Mitton.
Victim and
Present appellant.
that means he is the auntie, is the uncle.
Uncle Lordship.
If the victim's aunt is the sister of the appellant. There's some relationship. That just reminded me of Kushwant Singh's joke, na?
So-
His ex-wife with whom he had a son married his father, and then his son became his cousin, his brother, and then his father became his own grandfather and whatnot. So this reminded me of that. But still, you have not been able to clarify your
Page 14,
relationship.
my lord, page 14 cross part, my lord.
Page 14. Also reminds me of that Kohima when they were that Hornbill. A reporter was
Cross part of
interviewing that minister, that fat one.
victim.
And then he said, yes, to the minister.
My lord, PW3, my lord, page
Lordship-
cross part, page 14, my lord. My lord, find the relationship, my lord. Page 14.
The accused, who is this PW3?
PW3 is the brother-in-law of the informant. The younger brother of the victim's father.
Brother-in-law of the
Informant.
and informant is the mother.
Informant is the mother, and he is the victim's uncle, own uncle. Father's younger brother.
Okay, this PW3.
Yes, my lord. Page 14, your lordship would
So,
find.
PW3 is the uncle of, paternal uncle of this victim, correct? So the accused is the brother of husband of my sister. The husband of my sister? Okay. Brother of her brother-in-law,
Yes, my lord.
the brother of husband
That
of my
relationship I initially stated, my lord, he is the brother-in-law.
Not brother-in-law. it
He is the brother, actually the brother of husband of my sister. So basically, this PW3's sister
Yes.
is also the victim's father's sister.
Yes.
Huh? So basically, her auntie's husband's brother. Auntie's
Yes, Lordship. Auntie's husband, brother. Yes. It is correct.
So at last we have unraveled the.
Yes.
So he's no longer his own grandfather.
No, not that.
Not that. Okay.
Not that. Lordship, kindly come to cross part,
Yes.
page 10.
Yes.
At that time, I resided with my father, grandmother, and younger brother. The house of the accused Nepal guy was nearby our house. My father is blind. I worked in the said roadside shop of the accused for 2 years. I used to clean utensil there. At the time of the occurrence also, I was working in his shop. My mother has been living in Das Colony for last 4 years. with my maternal grandmother. Earlier also, I had gone with the accused for outing. So in that context also, she can state it that earlier occasion also he has committed bad act, Lordship, but that was not stated. Then your Lordship, kindly look, during the Kali Puja, I was in the house of Mitton for 3 days. I went to Nibia to the house of Mitton with the accused Nepal Roy. It is after 4/11/2021, Lordship. After,
Where do you get that date?
Lordship, it is cross-part, Lordship.
No, please do not put words with or dates. Which
A date in the Azahar, Lordship, as
we are reading the evidence.
And-
Please do not put that.
a lot. With the accused Nepal Rai after taking permission from my grandmother. So before proceeding at Nibia, permission was taken and then they went there
So what?
in their relative's house.
Usually,
So I'm not, I'm on the
usually
360.
this rape on children are usually done by known persons.
That is true, but that is true. But whether in a manner acquisition was made, which is
Let us-
believable.
Carry on reading.
I went to the Nibia to the house of the Mitton with the accused Nepal Roy. After taking permission from my grandmother, the accused paid me rupees 1,500 per month for working in his roadside shop. I read up to class 4. It is not a fact that I have falsely stated that on the day of occurrence, which was after 2-3 days of the Kali Puja, I went for outing with the accused Nepal Roy, who is brother of my said aunt, and that as it was late at night, the accused Nepal Roy took a room in a hotel on a rent of rupees 500 near SMCH, and that while I was sleeping, the accused removed my clothes and such, Lordship. At that, as I did not return home, my mother lost the cases, and that after that police brought me to the police station along with the accused Nepal Roy. It is not a fact that when my grandmother asked the accused Nepal for the money due to me, he refused to pay the amount, and then out of grudge, the instant case is lost against the accused, making false allegation. Prior to this occurrence, once I had to gone to Guwahati with the accused. It is also clear. Prior to this occurrence, once I had gone to Guwahati with the accused. But my submission before your Lordship, this incident was not stated to the police. Why her statement was recorded by the police or before the learned magistrate who recorded statement under 164 statement. There she stated another story.
Did you put that question to this witness?
But
The cross-examination?
is it required, Lordship?
Yes.
No, Lordship.
As per
No,
the
no,
Supreme Court
Lordship.
judgment,
Lordship, kindly.
if you want to discredit a witness,
No, it is true.
that the statement made under 161 the statements made there are not in your testimony. You have got to put that to the
Lordship,
witness.
Lordship, it is true. When?
What do you mean?
No, Lordship, it is true.
law.
When it is? When? If the accusation is some way or other related with the charge, that prove the charge. Here it is a case, he stated something else that no way connected with the charge framed against the accused. So he should remain silent. In that event, if the charge was altered at the relevant time, he can put question. Here, Lordship, at the relevant time, the charge was that alleged incident occurred at the house of the accused. So why he is to cross? Is there any law, Lordship? If any fact not tested through cross, adverse presumption can be drawn against the accused. It is not like the 106 of the Evidence Act. The failure on the part of the accused to disclose some fact leads to some inference. It is not that some facts were not tested in the cross that was made by the victim before the IO, but that nowhere related.
My lord, one line explainer is there, my lord. Page 76, 164 statement once again, my lord. Kindly see. Page 76. Last 3 lines, my lord. Very important. Last 3 lines. Page 76. Malati Malaka brought me back home. Thereafter, again, the new story starts. My lord. On 4/11 at 5 p.m., I, along with Nepal Roy, went to his sister Miton's house.
Huh.
I informed my gentleman about the same. We resided there for 3 days. After that, I returned back with
He,
home with Nepal. Now, kindly see the evidence at page 10, my lord. Once again, my lord. For a
please.
Okay, madam.
Please.
I'll just say. Now,
After,
the cross one step.
yes. Lordship kindly last
Please
3
mention
lines.
again.
After 3 days, she returned back. And thereafter, in the trial, new story that I stayed at SMCH after returning these 3 days. He stayed at a hotel. These after 3 days. What he stated in her 164 that we stayed there at the Nibia for 3 days. Nibia at Koringan Lordship, perhaps aware. Nibia at Koringan Lordship,
And
in
SMCH.
the district of SMC at Kachar. She stayed there with the accused for 3 days and thereafter returned.
What is her age?
Her age, Lordship, I am not going.
12 at the time of
Oh,
incident.
12 at the time of
At the time
incident, but
evidence
I am
was
not.
spurious.
You don't want to go to that age.
No, but Lordship, it is, but age aspect, I am not, Lordship, contradicting.
According to
But-
you,
But charge is not framed. That is my contention,
according to you,
Lordship.
there was no sexual intercourse between you and the victim.
Lordship, that is not at all. Lordship, but that I cannot say before the honorable court. I personally know the accused, Lordship.
You personally
That
know
is, yes, that is no way. But that I cannot say. That I cannot say before, but evidence,
Why are you saying it?
Lordship, not. But that I am sorry for that. I am sorry for that. I should not say it before the honorable court. But I am only on the evidence on the court.
While saying that, you cannot say you have already said it 10 times.
Lordship, sorry.
It's like saying, I don't like samosa. Samosa. I will not eat samosa. I will never eat samosa. It's like that saying that.
But evidence on the record, Lordship, whether inspired the confidence of the honorable court to sustain conviction by first submission, whether accused was put to the charge, whether natural justice is violated, whether finding of the learned trial court is perverse. That aspect, and Lordship, also, Lordship, I am also further seeking Lordship permission to submit a written argument also, Lordship.
Lordship.
Immediately after vacation.
Wait a minute. Very bad.
ঠিক আছে এটা বলি কপি আপনি দেখুন আমার লাগবে করিব মই দিদিন কিন্তু দেখি হয়ে যাব যাচ্ছি রিটেন ম্যানেজমেন্ট এটা দিই
And yes, anything else?
Lordship, only rest, Lordship, I may be allowed to submit written argument if your Lordship allows.
We'll see. Yes,
Lordship, I don't have the paper book. I'm going through the LCI, Your Lordship. Lordship will kindly see whether the evidence of PW1 inspires the confidence, my lord. Although my learned friend has made the submission, the error in framing shows during in the trial proceeding whether he has taken the plea and whether 464, Your Lordship may kindly have a look.
madam,
My lord.
madam, before you go to.
Yes, sir.
Let us see the CRPC. Charge.
464,
Let us see
error in framing charge.
what,
Lordship, before that 412, 220, 212.
just,
212.
Effect of omission. Omission of framing, sir.
just come to 212. CRPC.
Particulars as to time, place, and person. The charge shall contain such particulars as to the time and place of the alleged offense, and the person, if any, against whom, or the thing in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. And the accused is charged with criminal breach of
No, basically that's
Yes.
21.
Yes.
To 1.
Yes.
Now, how did the trial court frame charge with regard to the offences? Keeping in view the particulars that have been mentioned by the IO in his charge sheet. Let us go to the charge sheet. Page 91.
Contains at page 93. The prosecution story in brief. Story of the case is that on 8/11/21, the complainant lodged a written FIR to the effect that the complainant's minor daughter, namely Divya Malakar, lived with her father at Kathal Road on 4/11/2021, while the complainant's minor daughter gone to parlor shop. The complainant's minor daughter Divya Malakar kidnapped by accused Nepal from the shop at Kathal Road and his mobile number is so and so. During investigation of the case, is that prima facie and so has been found well established against the arrested accused so and so. So talks about an offense. Lordship, may I see?
When, which date, how did the learned trial court fix a date? When did it happen? And let us see this, whether the FIR was filed on 8/11. It was filed on 7/11.
It was filed on 7. No, it was no. 8/11, my lord.
Where,
Phase 1.
page page 4. Come to
Page 1 of the paper book.
page 4. Page 4, you come to page 4.
Maybe there's some GD entry or something.
I don't know.
GD's reference is also there. TOP
No,
GD numbers were.
Page 4, madam.
My lord.
The investigation is being done on the basis of the GD entry or on the basis of FIR?
Page 5 would clarify, madam. It was initially in the Rangiri Transit Outpost and thereafter it was sent to Silchar PS, madam. Page 5, madam. Last part, madam. Receive and registered.
Rangir Khade TOP.
No. It says FIR. Where's the FIR?
FIR is at piece 4, my lord.
Yeah, where's the
Talk about 411 incident. Whether the this one investigating authority initiated the investigation on the basis of GD entry. Yes. A reference is given, your lordship. Yes.
Now, from where did the charge, from what are the basis for the charge frame? That on 411 this happened or this happened. There's nothing mentioned here. In the charge sheet. Charge sheet is benefit of particulars.
May see the original because 4 sometimes is written like that. Assamese 4 is like in vernacular is like this one
Sure.
8 Milo. Oh shit. Continue to say FIR. But the reference to FIR number 811. Oh, that's what GD pro, TOP pro. Oh. You don't know?
আপনি যাতে দেখে নিল তাই গৌরব খাই কিন্তু আকুশ অন 4-wheeler আই এলং উইথ নেপাল ওয়েন্ট টু হিজ সিস্টার তাকে 3 দিন হি থাকা বুলি কৈছে এই 3 দিন পিছতে ৰাতি দেৰি হওঁতে সিং এসেঞ্চিয়েল থাকিবলৈ বেয়া কামটো কৰিলে তো এইটো আছে আপোনাৰ এই part of South. Back question. During Kali Puja, I was in the house of Milton for 3 days. I went to Nibia of the house. In Nibia, also of the SMGS. And I that he to be to see.
Yeah.
No, shame, it's written as 8 Milo.
So where has it been written as it? Sure. Where it has been written as it?
Here, it's written as 8 in
Okay. Right.
English.
So there was a mistake.
You mistake, your lordship. Because this victim, because she's honest in submitting, because
No. We are not saying that
she's
she's dishonest.
my lord,
We are not saying this.
Yes, my lord.
We are not saying that she's dishonest.
my lord,
What we are saying is
there's error, my lord.
not only error. There is nothing in the charge sheet. So how did the learned trial court get all those facts and figures in the absence of anything reflected in the charge sheet? Charge can be framed only on the basis of the charge sheet,
None.
not on the basis of something that we don't know.
Surmises and conjecture.
Yes. So how do we? So how did the learned trial court frame the charge anyway? And then the evidence is with regard the charge is with regard to an incident that occurred in his house. But the evidence of the prosecutrix is that it happened in a hotel.
It's okay. Lordship, today I'm handicapped, my lord. I didn't have the paper book. Actually, I don't have. Lordship, today I don't have the paper book since Lordship said that your Lordship will take up the matter, so I did not say anything, my lord, make my submission. At 10:30 made a mention.
We said we'll hear him.
Yes, my lord.
We didn't allow him.
I did not make my submission that I don't have the paper book, my lord. From the records only I'm seeing it, my lord. I don't have anything with me today.
There's nothing here. Madam, you have not missed anything. There's nothing to miss.
Error in framing chairs, my lord.
There's nothing there. No, forget the error. Forget the error. Now the issue is with regard to whether it's with regard to 411 or 211. Let us hear evidence. Her evidence.
PW1.
Let us hear evidence.
Yes, my lord. The informant at page 9.
Yes.
The informant is my mother. The occurrence took place last year, 2-3 days of yearly Kali Puja at about 8 p.m. During the Kali Puja, I went to the house of my aunt Mitten at Nivea. On that day of occurrence, which was after 2-3 days of the Kali Puja, I went for outing with the accused Nepal Roy, who is brother of my said aunt. As it was late at night, the accused Nepal Roy took a room in a hotel on rent of rupees 500 near SMCH. He brought meal for us. After eating the same, I slept. While I was sleeping, the accused removed my clothes and forcibly committed so-and-so. As I did not return home, my mother lost the case. After that, police brought me to police station along with accused Nepal Roy. My parents were also called to the police station. Thereafter, I told my mother about the occurrence. Police sent me to SMCH wherein my medical examination was done. After that, I was sent to Ujjwala home. After 2 days, I was produced in a court wherein my statement was recorded by magistrate. Exhibit so-and-so are my signatures. At the time of occurrence, my age was 13 years. At that relevant period, I was residing with my parents in the rented house at Kathal Road, Silchar. Accused Nepal Roy had a roadside pulao shop at Kathal Road. Police recorded my statement. At the time, I resided with my father, grandmother, and younger brother. The house of the accused Nepal Roy is nearby our house. My mother is blind. I worked in the said roadside shop of the accused for 2 years. I used to clean utensils there. At the time of the occurrence also, I was working in this shop. My mother has been living in Das Colony for last 4 years with my maternal grandmother. Earlier also, I had gone with the accused for outing. During the Kali Puja, I was in the house of Mitten for 3 days. I went to Nivea to the house of Mitten with the accused Nepal Roy after taking permission from my grandmother. The accused paid me rupees 1,500 per month for working in his roadside shop. I read up to class 4. So, Lordship, incident has taken place that time only.
Where?
I went to Nivea to the house of Mitten with the accused Nepal Roy after taking permission so-and-so. It is not a fact that I have falsely stated that on the day of occurrence, which was 2-3 days of the Kali Puja, I went for outing with the accused Nepal Roy, who is brother of my late aunt Mittal. And as it was late at night, the accused Nepal Roy took a room in a hotel room, so-and-so.
There is nothing with regard to the house, that the girl being raped in the house of the appellant. Nothing is stated.
Let us see 164 statement once. Or 164 statement one. 75. On 2/11, at about 6 p.m., Nepal asked me to sweep his house. When I went to sweep his house, he pushed me on the bed and undressed me. So and so, my lord. Thereafter, he left. I came out of his house crying. His wife, Jharna Ray, saw me and asked me to the reason I was crying. I narrated the entire incident to her. She asked me to forget about the same and not inform anyone about it. In the evening, my cousin Liton Roy took me to his home. On the next day, Jharna Roy and my grandmother Maloti Malakar brought me back home. On 4/11, so and so, along with Nepal Roy, went to his sister so and so. I informed my grandmother about the same. We resided there for 3 days after that.
There's nothing here.
Lordship,
You see, this 2/11 incident has not been mentioned at all by her. And then that mention which is mentioned here has not been mentioned here in the in her.
Lordship, 64 statement is a corroborative piece, my lord.
Correct, but then it can also be used for contradicting a witness.
Lordship has to read it along with substantive evidence along with dates, my lord. He may miss something.
No, but everyone is missing everything. From the IO also he's missing all the dates. The witness also, so it doesn't inspire our confidence when there's so many missing gaps, so many gaps in the prosecution case.
Can it be a lordship in the new year?
Yes, what have you got to say? We'll hear you.
First part.
You have not filed the IA.
I have filed lordship, but already lordship
Rejected.
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 Or rejected.
earlier rejected.
That's what you should. You have to press for this hearing. Anyway, you can file another IA.
If required, lordship, I can.
My lord, my first submission will be, my lord. Even the FIR clearly speaks about 4/11. Now the mother is not knowing about anything. He was only informed by the father of the victim, my lord, that she is not there at the home for last so many days. That's one part. So, first, my lord, I'll just read out the FIR for a moment, my lord. I have the honor to state that my daughter Divyamani lives with her father at Kathal Road. Last Thursday on 4/11/20, my aforesaid daughter went to a pulao shop situated so and so. Nepal Roy, he is the owner of the shop. He kidnapped my minor daughter and took her somewhere.
He said he kidnapped. Informant says the Nepal Roy kidnapped. But the evidence of the victim is that she went with Nepal Roy to his sister Mitton's house.
That's
It's a
correct.
question of kidnap.
But that's correct, my lord. Now, my lord, 4/11, the date is here, my lord. The date is here.
So
After this, my lord, police brought them to the police station, my lord. She was sent to the magistrate for recording her 164 statement, my lord.
No.
In the 164 statement, my lord, again, slowly I'll read out, my lord. 76 last 3 lines, my lord.
yeah,
On 4/11/2021 at 5 p.m., I, along with Nepal Roy, went to his sister Mitton's house. Now, my lord would kindly appreciate one part, my lord. Mitton's house.
yeah,
I informed my grandmother about the same. We resided for 3 days.
yeah,
Now, my lord would kindly come to page 9, PW1 evidence, my lord, for a moment,
yeah.
to my humble understanding, my lord. Third line, my lord.
Yeah.
On the day of occurrence, which was after 2-3 days of the Kali Puja, I went for outing with accused Nepal Roy, who is the brother of my said aunt Mitton.
Yeah.
So he went at Mitton's house only, my lord. And
Correct. That's what he said. You went to Mitton's house.
I was, as it was late night, Nepal Roy took a room in a hotel of rent of for 500 rupees. And there he did something wrong. So, my lord, the second part of the 164 statement, from 4/11, they stayed for 3 days. And after that, a room was taken. That part is there, my lord.
There is nothing stated in her 164 statement
correct, my lord.
that she was raped on 4/11.
No, that part is not there. Because why I am saying, because in order to assist this honorable court, my lord, in the medical examination, she says that
64, she was raped only on 2/11, not on 4/11.
my lord, page 16 medical report for a moment, my lord. The doctor who deposed, my lord.
One is in Assam is vernacular.
What does it say? If it's in vernacular, for me, it's Greek. Very badly investigated. Kidnapped by the apparent. But the 164 statement does not prove this. Evidence of let us see what the IO says.
PW4, my lord. PW5, sorry.
That's all.
Defective investigation is not that. It would, you know. No, Bharosa Swali.
We've got a meeting.
After the.
After vacation, my lord.
Why?
Well, in the meantime, my lord, I also need to show certain judgments, my lord, because the Supreme Court is very clear. But my lord, defective investigation is no ground to, my lord, give benefit to the accused if there is a defective investigation.
We bring everything to one.
My lord.
I don't have paper book. I have just collected from
You, okay, day after tomorrow. Day after tomorrow.
Thursday.
After lunch, we can do it.
No, my lord.
Yeah.
Some other day, my lord, because I need to take out the judgments also.